All righty, ladies
Yeah,
and gentlemen. Mr. McNamara, do you have an opening statement, sir?
I do. Thank you. So I've read the recommendation. Unfortunately, I was not present for that conversation. I do not know how on earth this happened, but I was not aware that this was happening. Um, I assume I should have gotten something in the mail, something like that. Um, I never received anything. There's no
Well,
way I wouldn't have.
normally I'd be able to confirm with you something, but both of you
Yeah.
have listed your
Okay.
addresses as confidential, which means
Oh,
it will never be listed in the court file. I've got,
interesting.
I've had a few of these lately, and I'm generally able to say, and tomorrow I've got another one just like this, and I'm going
Hmm.
to look at them and go, your address has been this address for
Yeah.
at least 4 years, according to the court file,
Yeah.
and this is where because it's the same argument, they didn't get it.
Yeah.
But
And
yeah,
no excuses for that.
no,
It's
no,
just I obviously would have been there.
well, let
I'm
me
here
ask,
today
are
because it's
you
an
are
important.
you on Royce Road
I am, yes.
in Weberville?
Yes. That has been my
I
address
ha
since I
I
moved to
do
Florida.
I
It's my
do I
permanent address.
do have an order in here from 2023
Hmm.
that lists that as the address. That's what the front of the court would have
Yeah.
been using.
Yes.
So
Yeah.
that's where it would have been sent
Mhm.
because that's the address the court has. So I did find in here, I don't know why it's currently listed as confidential for both of you,
Yeah.
but there was a support enforcement order also in December of 2023 that was
Hmm.
issued by the front of the court who sent you both the
Yep.
recommendation, and that lists you as on a Royce Road. I
Yep.
don't know how it got converted to confidential for both of you, but it did.
Yeah.
But at least the
Interesting.
file does have some things like that, so I can confirm that that was your address. And if that was your address that the front of the court used in December, they would have used it in February when they sent
Yeah.
this to you. So I don't know why you didn't receive it. So
Yeah, I don't either. It sounds like it's something that's been happening. It's neither here nor there. The purpose for today is, and my opening statement here is, I don't want to go through the 42 separate, allegations that are listed in that recommendation. Everything from I'm a crypto millionaire to I travel the world all the time, and show my daughter love and affection through money and gifts, which I have
well, I
no
have
money
not,
to buy gifts.
as I told you at that
Yeah,
time at the motion, I have not read this recommendation. I've
yeah,
read the order that was recommended. I have not
sure.
read the bulk of it because I'm not allowed to until
Hmm.
we get to this hearing. And if you agree to allow for me to read it, that's one thing.
Yeah,
Or if I
I
think
do
I've
agree.
even I think I mentioned that one of the two of you should probably call the front of the court so they can be
Mhm.
questioned and cross-examined on
Mhm.
what they did on this. And
Yeah, the order is very clear. It's a thoughtful order by
yeah,
all
the order
means.
was clear. I mean,
Yeah, the order, all of the recommendations from the evaluator were very clear,
right.
based on the information that she had. Um, it says in most of the findings, that um, Miss Pimentel feels this, or she thinks this, or she believes this.
Hmm.
But I could believe that she was a werewolf, and
Hmm.
that should be considered, right? I feel like there's no evidence for anything that's in that order that I am dangerous to my daughter in any way, shape, or form. My daughter loves me, sends me text messages all the time with kisses and hearts, and I miss and love you, Daddy. The thing is one of the things in the opening statement of the recommendation states, that my daughter has been affected by my long and willful absences. I believe that to be true because my daughter loves me. I'm her father, and I love her. She's my daughter. Unfortunately, I made a bad life choice to try to save a relationship, and I moved to Florida thinking it would be a temporary thing to come back. I owned a home in Michigan, and I intended to move back to that home. I was thinking maybe 6 months to a year to put together our our family. Um, as Miss Pimentel has created hers, I was working to do the same in my life. Unfortunately, that did not happen. Things fell apart when I got to Florida. Rents increased 40% year over year. I had to furnish an entire apartment, and I lost my job. So I got far behind on things, and I could no longer afford to fly to Michigan every 2 weeks when flights were $400. That's another $800. I couldn't even pay my rent. I went on unemployment, and just so I could try to get food, and that was like $360 a month, and my rent was over 2,000. So it was a series of events that occurred. I've been seeing my daughter consistently since December 1st of 2023. Um, Before that, when I was in Michigan, I had her 3 overnights every single week, and I exercised those without exception. Unless it was something I was out of town or something, we do a good job, I think, communicating with those things. Um, if there's, an anomaly, and we talk about these things in advance. Um, at the end of the day, I'm not sitting here right now saying I want more, and I certainly don't want to lose the what feels like a small amount of time I have with my daughter now, as opposed to what I had before. I had her, if I had her, I think it was 2 more overnights per month, we would have been at halftime. And I had to fight in court to even get that the first time, which I did with a lawyer.
But that was when you lived in Michigan.
That is correct. Yes.
And
I
you
see.
currently do not live in Michigan, correct?
I lived there for some of the time. Yes.
You don't
Not
currently live here.
permanently. I have a Michigan ID, so technically I'm a resident of Michigan.
I understand.
Yeah.
But do you live here?
Yes.
You live
My
in Michigan.
residence is in Michigan. I do not have a Florida
Do
residence.
you physically live here
Yes.
all the
All
time?
of Yes, all of my belongings are in
Okay.
Michigan. I do not have a lease or anything in my name in Florida. I have items that are in a storage unit there, uh,
Okay.
and I was working remotely.
Okay. All right.
When I did
Please,
get a
please
job
continue. I'm sorry. I thought I'd just clarify
yeah,
because again, the opening statement is not testimony yet. You're going to
yes,
have to
sure,
present testimony.
okay. So essentially, the purpose that I'm here, I'm not asking for more, right? I understand that regardless of what the situation was, that I failed to meet the parenting time expectations of not only the order, but as a father. Okay.
Mhm.
Doesn't matter if it was money, it doesn't matter if it's distance, any of these things, job losses, it doesn't matter. I accept that and I agree with it. I don't think the solution is more of that. I think the solution is more time with my daughter, not less. What I'm here to, ask for today, in the case that I hope to make today, is to keep the reasonable parenting time order that has been in place, and then revisit that at a later date when I've shown that, I am in a more stable situation financially, and I can provide, a more stable environment for my daughter.
How far away from the mother's house do you live?
It's an hour and a half
Okay. All righty.
currently. Yes, I'm currently
Okay.
unemployed. I was laid off again. The tech sector is struggling quite a bit. So I've been interviewing. I have a second interview tomorrow at 2 p.m. and hoping, you know, to secure employment. It's been tough, as you know. Many of the major corporations here have been laying off hundreds, if not thousands, of people. The economy's not great right now, so the average time frame for folks to get a job is 6 months. So doing everything I can to do that. And I understand that, to have a residence, in Grand Rapids, as I did before, and be there and more available to my daughter is when I would ask for more than reasonable
Well,
parenting time.
parenting time is always, are you on unemployment currently?
No, I did not qualify for unemployment
And why is that?
because I was not employed for 90 days.
Okay. I apologize for asking because if you're on unemployment, that's pretty much a get out of jail free card because that means that you did not lose your job through any fault of your own.
Sure.
So I
Yeah,
was trying to
unfortunately,
do
in this case, I've
Mr. Browning, I was trying to circumvent a couple things. I normally don't question during opening statements, but I was trying to set a record here because we don't have testimony yet. But if I can lay the groundwork, maybe there's some reasonable accommodations that could be happening here.
I am
Um,
receiving food assistance.
you are on state aid.
I am on state aid for food assistance and health insurance. Yes,
So you're on Medicaid and food assistance.
correct.
When did that begin?
I want to say March.
March
It took a
when?
of 2024. It took a long time to get everything going, and then I became employed in early January. I accepted a job
Well,
offer in
you were
mid-December.
employed when we had the motion, finally.
Yes, correct.
And that was, I believe, in
February, I believe.
February, yes.
Yes. In March, I lost my job.
But you scheduled the hearing for May 24th and you said you were employed as a W-2 employee.
I was when I scheduled it. I scheduled it like 3 months out so that
Well,
I could save money and get an
I
attorney
understand
to
that's what you
represent myself.
said, but on the motion hearing, you
Mhm.
stated you were employed as a W-2 employee at that moment. That's what you said
Mhm.
on the record.
And when was that?
May 24th, when we had the
Okay.
motion
I
that
don't know
granted
the
this hearing.
exact date that I lost my job, but it was, oh, in May?
Uh-huh, May 24th. I rewatched the hearing about an hour and a half ago
I
because
must have I must have made a
I
mistake.
kind of my memory sits in a metal box at the feet of my
Yeah,
clerk because that's
I
where all
understand.
the but when I rewatched the hearing,
Mhm.
you stated at that moment, because I asked you, and I asked you
Mhm.
specifically because I asked if you were a 1099 employee, because that's where that was sounding, and you said, no, I've been a W-2 employee all along. And I
Mhm.
said, so you're currently employed and you're getting a W-2, and you said yes.
Yeah, I must have misunderstood the question. I'm sorry. I've never been a 1099 employee. I've always been a
Well, that's
W-2
what you
employee.
said
That's
then.
true. Yeah. Yeah.
I granted you that. But then
Yeah.
you said,
Yeah.
no, you've been a W-2 employee. You've always been a W-2 employee. And I'm like, well, this will be clear cut. Get me a copy of the W-2, get me
Mhm.
a copy of the pay stubs, and I
Mhm.
can figure out what your income is.
Yeah.
You didn't say anything about state aid.
Mhm.
And you said you got state aid in March, but this was the end of May. And
Yeah.
and you are currently on state aid as well.
Mhm. Yep, at that time.
Okay.
Yeah, I'm sorry. I must have misunderstood.
Well, you're pretty clear. All righty. Mr. Browning, any opening statements?
Thank you, Your Honor. Mr. McNamara and Miss Pimentel had a rocky relationship, and that has been characterized on Mr. McNamara's part by gaslighting, emotional abuse, and just a general pattern of behavior which gives my client great concern, great pause. And Mr. McNamara has always been tough to deal with. He's never been forthcoming about anything. He's the opposite of straightforward. You know, I hate to even drag things in that he just said in his opening statement into my opening statement, but right now we've been here for a short time and he's already claiming to have not understood what was said when he said that he had a job, which had a W-2. And now he's telling us he's on state aid and he's telling us he's on Medicaid. So I guess he went quite quickly from someone with a six-figure income to someone who can't afford, you know, someone who's on food assistance. Now he lives in Michigan. That's pretty unspecific. I really question this client's honesty, and I know that my client has had many issues with it in the past. And that is why she likes to, she would request that we agree with the front of the court order. Thank you.
Thank you. All righty. Mr. McNamara, you may call your first witness.
I guess I would call Miss Pimentel.
Ms. Pimentel, welcome, and please raise your right hand, ma'am. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in giving testimony?
Yes, I do.
All right. Please proceed, sir.
Yeah, I guess regarding the rocky relationship that we've had, what time frame are you referring to by our rocky relationship? Is this pre-separation or post-separation?
All of it. However, I am really only going to talk about the things that occurred within the last 2 years, as that's what is pertinent to this case.
Okay.
Okay, so when you mention a rocky relationship, you're referring to the last 2 years.
No, I'm referring to the relationship with you that lasted 7 years and then the post-separation.
Okay, and what does our, I guess, relationship over the last 2 years look like? Can you give me some examples of what ways I was difficult with you?
Yes, I have a lot of examples with text message evidence that I've submitted to the court that I have also here. The most notable is there was an incident where Michael McNamara deliberately withheld information about a warrant that he said he had paid, and I allowed my daughter to go visit him in Florida. I asked him to please make sure that that warrant was taken care of prior to her coming down. Because if he were to be arrested and taken into custody, my child would go to CPS. And he assured me many times in text message that this was taken care of. In fact, he went so far as to say that it stings to waste $1,800. Later that month, in a few weeks, after my daughter had come home from this vacation in Florida to see her father, my case manager, Mike Prendergast, was speaking with me and confirmed that Michael not only had not taken care of the warrant, had not paid on it, but had never contacted the friend of the court at all on it. He was later arrested for this same warrant for non-payment of child support arrears. And if I had known, I would not have let my daughter go down to Florida because she would have been placed in CPS had he been arrested while he was down there. And so he willingly lied and was dishonest about that and endangered her life with that. He also, in an attempt to pay off some arrears, chose to circumvent the court and wanted to pay me out of the friend of the court system, which I was willing to do as long as it was all documented so that I could submit receipts. And I have the text message evidence of his coercion, suggestion, and attempts here to convince me to lie to the friend of the court and inflate the amount of money I had been paid because, as he states, that he should not have to pay for any time that he was unemployed. That is a waste of child support. And so I have all of those text message evidences of coercion here, should I need to present them. He also lied about having an available space for her in Florida. I asked repeatedly, can you please update me as to your living situation? And he repeatedly stated that his living situation was fine and that she was able to come down. After some more probing, I discovered that not only does she not have her own room, she's expected to sleep in his bed while she is down there. There was no space for her and no space of her own. There is a lot of different evidence in my texts. Those are the most important ones that I feel without getting into other ones that I have as well.
Follow-up question to that. What month was this that Margaret came to Florida and I had a warrant for non-payment?
Let me see. That would be on November 16th. I asked you to make the payment before she went down. On April 20, which was the next time you requested that she come down to Florida, I reported that I would not be able to let her down to Florida anymore because you told me you had taken care of the bench warrant and you had not.
Let me clarify. Hold on. April of what year? So that I have it with my notes at the,
2022.
Okay, so that was 2 years ago. Okay.
Yeah.
All right, thank you.
And when I was behind on child support and I did wind up being arrested for failure to pay child support, was this before or after I sent you $6,000 through Zelle and we agreed that you would remove that from what I owed because I didn't want to pay $350 or $300 in fees because it's a $50 charge per 1,000.
So the text message evidence that I have for the coercion suggestion has your text messages saying.
That wasn't the question. The question was, when did you receive those funds from me and how much?
I am looking. It was $6,000, and I have the statement here where I mistakenly had that as $4,000 for a while. I have the statement of state payments received in coercion, which I can read to you if you like. Payer on the case, Michael McNamara, has requested I report a payment he made outside the courts in October of 2022. I am submitting confirmation of this payment, which I mistakenly report in previous documents as having been $4,000, which was my error. My delay in giving credit for these payments is due to the payer's attempts to coerce me into deceiving and lying to the friend of the court about the total payments received. He suggested that to help him pay less than he thought he should, I should simply report that I received more than what he actually paid. This made me extremely uncomfortable, and I did not want to be taken advantage of, and thus I reported it to the Attorney General both in an official complaint and in my victim paperwork. I also spoke on the phone with the FOC seeking advice, as well as my case manager, Mike Prendergast, and his statements indicated that if the payer chose to make payments outside the course, then that was his choice to circumvent reporting. I have included bank statements from October 2022, which you may note payments received from Michael McNamara for amounts of $1,000 6 times. I have also included the letter that I sent to the court for that last show cause hearing in, I believe it was December. There's currently another show cause hearing scheduled right now for arrears. And that is,
I have no information about this hearing, by the way.
I don't
So
either. So
just, yeah, it's a
have-
second thing. Again, I have no information about a hearing.
I
Is
received
that a
my
question, Mr.
information.
McNamara?
well, I was going to say, is there a
No,
question
no,
in there? I'll take judicial notice that
I'm
you don't
happy
know
to
about.
ask more questions if I can go.
Yeah.
I
Well,
think, yeah.
this is your witness.
So-
You may ask the questions.
So I guess if you were uncomfortable, right, reporting more than what I had paid, why are you so uncomfortable reporting what I actually did pay? I actually lost a job due to going to jail for money I had already paid. And in the last show cause hearing, I was put in jail because I was behind the exact $6,000 again that I had already paid, that is on record as you agreeing that I had paid towards child support through Zelle in October of 2022. Those funds are still not reported. Can you explain why you're refusing to report that information that you're
Yes. As
verifying I paid?
As I stated in the arrears letter that I sent to the front of the court on December 3rd, 2023, and as well, the court also called me during one of my classes while the show cause hearing was in session. And this is the letter I instructed to give them. And this was also the statement that I gave them over the phone, which they accepted, which was, I have received an arrears forgiveness form from the payer on my case, Michael McNamara. As per the instruction of my lawyer, I am not completing the form owing to the payer's documented attempts to coerce me to deceive
Wait,
the.
Hold on. Did you accept the $6,000?
Yes, it was due. It was through.
And you have not acknowledged that $6,000 that
No,
you.
I have submitted payment. I
Okay.
acknowledged it
Then
several
please,
times through the
that
front
would
of
be the answer to the question, please.
Okay.
I'm trying to figure out.
There would not be a show cause hearing scheduled.
Sir, you're
magnificently again.
according to November of 2023, you were in arrears is $9,500.
Minus the 6,000 that she had not.
Okay,
and
that's
still
$3,500 when the current order is, I believe, 950. So you're at least 4 or 5 months in arrears.
The
Correct.
current,
And I was
that
unemployed
time.
for 6 months.
Yeah.
Yes.
the current amount of arrears is 11,117.
And does that include the 6,000?
That does not include the 6,000. My lawyer has recommended to me not to complete that forgiveness letter.
Really? You accepted $6,000 and you did not complete a forgiveness letter?
I did not complete a forgiveness letter until requested, and I did report that money outside of the court system several times, both in.
So has the front of the court taken that into account and taken it off what he owes?
They have not taken it off what he owes, but they know it was received and have taken it into account.
I've gone to jail 2 times for this payment.
Well, there's problems because you owe way more than that. But at the same time, I'm trying to determine, because I have conflicting evidence here or testimony that says, did you or did you not? And all of a sudden I feel like I'm in the movie Clue. Did you or did you not acknowledge this? And you're saying the front of the court, you've acknowledged it, but the front of the court has not accepted it?
I have acknowledged it several times, both when I sent that letter stating that I received it and why I was not completing the letter.
But you never completed the letter, which means they can't accept it.
Correct.
No, they have not accepted it.
Okay. So you've received $6,000 that's being held against him when you refuse to acknowledge the fact that you had cashed the $6,000 worth of checks.
I have also said that I am willing to forgive that moving forward if we can actually get some payments made, because he's still not.
And some of this was set up because of the fact that you have not acknowledged the fact that you actually cashed checks you received.
I guess I was confused on what acknowledgement.
There's no confusion here. You either accepted it or you didn't, and you cashed them.
I did accept it then, yes.
Yeah. Okay. Please proceed.
And I guess the follow-up question to that was, why did you agree with me? I also have text messages. I actually appeared to the show cause with the text messages and all of the Zelle receipts for the money I sent, dated, time-stamped, and your acknowledgement of receiving all funds and the purpose of the receiving of those funds. Yet still to this day, you have not filled out the forgiveness form. And for some reason, your lawyer is advising you not to forgive the money that you've received. What is the strategy behind that?
Because the full payment of arrears was $10,000. You stopped short at $6,000 because you did not believe you were responsible for the full 10,000. That is the point in which I got nervous. I consulted with my lawyer. I revealed the coercion that you were trying to deceive both the court and get me to lie to the court, which put me in an uncomfortable place. The full amount of arrears was never paid. That 6,000 was part of a larger part of a sum you did not want to pay.
And as a follow-up question to that, do you have evidence that I actually had that money and was prepared to give it to you and was withholding it? Or did I actually have the money to give you at that time?
Objection.
Yes, in
Objection.
the basis of the objection, sir.
He's asking her to speculate on information she wouldn't have. That being how much money he has available to finish that off if he so chose.
Lack of knowledge, but
I agree with that, but there's a lack of knowledge the other way as well.
She may answer as to what she knows or does not know to that extent. So I'll hold the objection suspended until she answers the question.
All I know is what I received, which was only 6,000. I have plenty of text messages.
Again, but you did actually receive the 6,000, and sir, you owed a bunch of more money.
Mm-hmm.
Neither one of you
I owe 10,000.
Neither one of you are correct here.
I owe $10,000 to $11,000. I had been unemployed for 6 months, and during that time,
understood. But neither one of you are correct in this situation, ma'am. You acknowledge what you received, even though he owes more. At least you received some, because the consequences are, if he is held to a higher amount that he's owed, it can mean more time incarcerated. So, you've got to acknowledge what the reality is. Yes, he still owes the money. That's still there. But you got to acknowledge what you received, because otherwise it could affect the sentencing. So at this point in time, again, neither one of you are correct. And I understand if you felt like you were being coerced to say more, obviously you didn't have to say more, but you should have said what you actually received, because you were willing to cash the checks. And I can understand why, because he owes a bunch of money. But at the same time, reality is you received money. You should have acknowledged it and said, and then you could have made your argument. Hey, he's coercing me for more. Do something about this. And they would have. It would have been a much easier and cleaner thing at one of the show cause hearings.
I will remember that in future. By submitting my letters of statement, I thought I was acknowledging.
No, you did not. You needed to acknowledge what you actually received, and then you could put on there that you reserve, in accordance with what's attached, that he was trying to coerce you for more, and you refused to do so. You will only acknowledge what you actually received.
It is a very difficult thing to jump into legal procedure. Thank you.
No problem. I'm just trying to, my problem is that both of you have cascade affected some things that I don't think either one of you intended, because you want to stand on your own beliefs. So, like I said, neither one of you are right in that situation. But sir, you may continue with your questions.
Yeah. So unfortunately, because of the amount owed, I was hit with a felony child support case and arrested, at which time I lost my job because I was in jail for, I believe it was 14 days. The Attorney General from Michigan actually dropped those charges. So those are gone. And upon returning to Michigan in December of 2023, I had a show cause hearing again for the same $6,000. I was told by the judge in court, if I did not pay $6,000 at that time, that I would be going to jail right now in that moment. Claudia was not present. And when the judge contacted you, Claudia, because this was a very serious situation, I had job interviews lined up and I wound up getting one of the jobs I was interviewing for 3 weeks later, the judge called you and asked you, did you receive the money? And you said yes. And after acknowledging that, the judge said, are you going to fill out the forgiveness form? And you said no. The judge then said, Michael is going to go to jail. The friend of the court said that by law, that's a gift. And I was taken into custody at that time. Again, for the same funds. You had mentioned on the phone as I sat there in court that you were not going to acknowledge or forgive those funds based on the advice of your lawyer. I'm sure, and some of this information may be privileged, so I don't want to cross any lines, but I'm curious as to why that strategic choice would be made, knowing the possible outcome, and then
Can you get
again,
to a
me not
question here,
being
sir?
employed. Yeah, I'd like to know, again, I'm going back to my original question that still has not been answered. What is the purpose of you not, for almost 2 years now, forgiving that money? You know how to do it. I provided you the form. You have legal counsel. They're advising you not to forgive it. For what purpose?
Now that I know the procedures in which to take and the seriousness of the matter, I can complete the forgiveness letter, but I would like to resolve the 2 years of non-payment continued, as well as several other issues in this case. But knowing that moving forward, thank you, Referee Kometz, I can complete the letter.
Well, and like I said, these are the unintended consequences done. He loses a job. We wind up chasing our tail because he can't get a job because he's incarcerated, because there's money that's been paid that should have been acknowledged. And at that time, things might have been able to be changed. Right now, we're now chasing our tail again, and the consequences have occurred because of what both of you did. And I'm not acknowledging that he owes back pay. He does. That's there. But he did make an effort at one time that, if acknowledged at the time, might have made a difference in how the payments are going forward. Again, both of you did some things that are going to harm both of you. And more importantly, you're going to harm the child.
Absolutely.
So please continue, sir. Obviously, she said that she was advised by counsel. It's been asked and answered. Okay. Whether right or wrong, she was advised at that time. And that's her testimony. Okay, so please proceed.
So I guess next question. There are a lot of statements in the recommendation that, again, according to Mr. Browning in his previous objection to my questioning, that were pieces of information that you could not possibly have. Some of the things listed in the recommendation are that you believe that I have a lot of money that I'm not presenting that I hold in cryptocurrency. Can you tell me how you're aware of that?
When we were in a relationship together, you were really into cryptocurrency mining. You will see in the recommendation that that is not a confirmed fact, but more something that I suspected. Your employment information is listed on LinkedIn as still being currently employed by FIS. So any information that I have on your employment comes from that LinkedIn profile that lists your employment since January 2024 as that current.
Are you aware that you can be open to work and it's only viewed by recruiters, and that on the LinkedIn platform you can control what certain people see and don't see on your profile?
Yes, but when you choose not to update the courts with any of your employment information or income, that is where we need to go to find things out. And they asked me specifically ahead of show cause hearings, can you update his address, his employment, his income information? And I try to cooperate when possible.
And just for the record, your information is all up to date and correct
Yes.
with the courts.
Yes, it states within 21 days of any kind of change of residence, income, insurance that you need to report it.
And if I can ask it, and there may be a challenge here to relevancy, but this is a line of questioning. Where are you employed currently?
Harris State University.
Anywhere else?
No.
Nowhere else. You have no other forms of income at all?
No other forms of income aside from occasional commission work and freelance, but that's very rarely, once in a blue moon.
Okay, there's nothing else, no other income. No other work.
Aside from my spouse who works, no, there's no other income.
Okay. And I guess in an ideal situation, obviously you had changed your request of the court to obtain sole legal custody and joint physical custody to sole custody, both joint or both legal and physical custody of Margaret. Can you explain to me why that is and how the problem being my absence now turns into the solution being permanent absence?
You are asking why I have requested sole legal custody in the recommendation?
Yes, you had requested full legal and physical custody of Margaret. And I'm just curious as to why that is. I noticed in the closing statements that you were asking if you could still allow Margaret to see me if that was actually granted. And if I'm so dangerous that I should not have, physical access to my daughter, supervised visits, these types of things, why would you want that option? I guess it was a little confusing.
These are things that I will list in my statements. Am I allowed to bring them forward now?
He asked the question, so you may answer the question.
In the last 6 months, sometime after February, I was visited by Harper McNamara, Michael's son, who detailed and counted to me because he asked me, please do not let my sister go to Florida anymore. And he revealed to me that his father had sexually assaulted him when he was younger. This, along with a series of domestic violence in his court records, obviously the willful endangerment of the child, bringing her to Florida while he had an active warrant. There is evidence of animal abuse and more domestic violence in his mother's house where he stays, which is why I requested supervised visits, in addition to him having a third
Can I
felony.
object to this?
No, you asked the question. She gets to
Okay.
answer it. You may do a follow-up question, sir.
Okay.
And I will note that I'm looking at the file now, and there is nothing in the file that says anything about domestic violence or
This is
anything of what she just stated. So,
because that information was disclosed to me after that recommendation.
okay. Because I'm like, well, you kind of indicated that it was in the file, but it's not anywhere in the file. So,
To
all righty.
clarify, Your Honor, I
Yes,
think
sir.
that what she said was that she was
It came,
going to bring that in her case in chief is what she was trying to say.
okay, and that she may do as well.
Right, right. That's what you meant by in the file.
Okay. In your file. I apologize because you started to say that, and I'm looking through the court file all of a sudden, going, had nothing like that in the file. Was not prepared for that, but again, that's why we do hearings, so that you may present such information and evidence. All right, please proceed, Mr. McNamara. But like I said, you asked the question.
Yeah. I believe that this is complete and total hearsay. I have not spoken to my son in almost 4 years due to other issues. I never abused my son. I never, ever even spanked my son his whole life, nor Margaret. I've never abused a child in any way, shape, or form. And there is no evidence of this whatsoever. This is an extremely substantial.
Sir, this is not your time to testify. This is your
I'm
time
sorry.
to ask questions.
Okay.
All right.
Ms. Pimentel, do you have any evidence of these statements to be factual?
I do. I have a notarized statement from Harper, and I also have him here as a witness.
Oh, okay. I would love to hear more about that. Are you able to read that notarized statement?
May I read the
No, no. I'm going to object to that. That's pure hearsay. We have Harper here. You may call him as a witness at the appropriate time. And he
Okay.
is in the waiting room. My clerk has notified me of that.
Wow. Okay. I think those are all the questions for Ms. Pimentel that I have.
All right, cross-examination, sir.
Thank you. Just on a couple things. First of all, a little housekeeping, Your Honor, just to make it clear that in this instance, my questioning of Ms. Pimentel will be limited to cross-examination of Mr. McNamara's
I,
case in
I,
chief?
I was going to offer that you could also just call her as a witness and forego your cross-examination, but whichever way you wish to proceed.
I guess I'd rather proceed in as if he had called her as his own witness and merely cross-examine her and then circle
Certainly.
back to having her up. Also, then it'll be easier if he somehow has any other witnesses.
Of course.
Okay. Okay. Thank you, Your Honor. All right, Mr. Mental, regarding this amount that was paid to you by Mr. McNamara.
Yes.
Can you clarify why it is that that attorney you had at that time, who that was not me, correct? Okay, why that attorney made the distinction between writing a letter and not writing a letter of forgiveness?
Um, all I was instructed to do was inform the court that my attorney had told me that, as advised, I should not forgive the arrears because they were done outside the court with the coercion.
So in terms of, this was meant in terms of yes or no, forgiving the entire arrears or not forgiving the entire arrears?
It was a yes to forgiving just that 6,000.
Okay, okay.
I was going to
Have
say,
you
as
ever,
far as I know, Mr. Browning, it's an acknowledgement that you actually received funds, and it was with the intent of those funds being for child support. That's why I was
okay,
confused. It's like normally that's a pretty straightforward request. Did you
okay,
receive money? Was it for child support? Thank you very much. We're gonna knock that off. Whatever else is out there, we keep and we'll keep going after.
okay, okay, thank you,
That's
Your Honor.
why I'm a little confused.
I did not receive a letter of forgiveness until December of that month. So that was the first time I had even seen something like that as well.
Okay, all right, and well, regarding other things, you also testified that well, actually, I would just like to limit it to that. Oh, now you testified that uh, he was that you observed on LinkedIn that he was still working for FIS, and then that went back to January, correct?
Correct.
And did you have any reason from observing that LinkedIn to think that he was no longer with FIS?
No,
Do you have any contact with Mr. McNamara outside of court proceedings?
no.
You do not.
Oh, I'm sorry. We
Okay.
do communicate on our daughter, dropping off and when he's going to see her.
Okay. At what point did he inform you that he had moved back to Michigan full time?
Never. I have not known that he has moved back to Michigan. From his last communication with us, it was that he was still living with a girlfriend in Florida.
And when was that communication?
May, June.
Okay, so really recently.
Yes.
Okay. And so he he never said, "Hey, we need to adjust this child support. I'm no longer working," at any time.
No,
Right. And was he aware that that could happen if he lost his job?
I would think so.
Okay. Let's go back to this LinkedIn issue. Um, do in your experience, do people continue often to list themselves with employers who have laid them off or let them go on LinkedIn?
No, that is not my experience.
In fact, wouldn't you say that they often advertise their availability through LinkedIn?
That is correct.
Have you ever known Mr. McNamara to have a highly paid information technology job?
Almost the entire time I have known him.
Okay. So did you have any reason to think before this hearing that he was no longer working in said job?
I did not.
Do you believe him when he says he's lost his job?
Yes.
Okay. Do you believe him when he says he's moved back to Michigan full time?
No.
Okay. Okay, no further questions on the cross-exam, Your Honor.
Okay. All right, sir. Next witness.
I have no other witnesses to call at this time.
Okay. The current parenting time is reasonable as agreed, correct? Basically.
Yes. Every
What
other
was the-
weekend, 2 weeks in the summer, split holidays.
Okay. When was the last time you saw your daughter?
Well, I was supposed to see her this weekend, but I received a text message that I was not going to be seeing her during my parenting time as scheduled because Buddy was taking her up north.
This is because Michael requested previously to have her for a week. And so I said,
Okay.
yes, it's fine because he's allowed that week. And so
Right.
2 weeks
Okay.
in summer.
Okay. So the
clarification,
current parenting time is being followed,
yes,
but it's being followed with the understanding that he's not in. Well, ma'am, you say that you believed he was in Florida.
but
Sir,
he's flying up twice a month.
sir, and you're saying you've moved to Florida permanently now.
Yes, I am a registered
I didn't ask
resident
that.
of
I
Michigan,
asked if
and
you were
I'm living in
living
Michigan. I absolutely am.
and
I
you live
do
here.
spend time in Florida as well. I do have a girlfriend here, and I do spend time here when I am
How
not with Margaret.
how often do you spend time in Florida?
Maybe 5 to 7 days per month.
And why do you go to Florida?
I have a girlfriend here
You have a girlfriend here. Well, if you have a
in
girlfriend
Florida.
here,
I have a girlfriend in Florida. Yes, I have a
and
girlfriend
you
in
keep
Florida.
saying that that's here, that indicates that
Mhm.
you live in Florida.
No, it indicates I'm in Florida at the time.
Huh.
I can only be a resident of one state, and I am a resident of Michigan.
Sounds rather Freudian to me, but okay.
Mhm. This is the truth. And I went and renewed my Michigan ID. They cut my Florida one. All of my mail comes to Michigan. I live there. All of my belongings are in Michigan. I was working remotely, which was nice because I could come back and forth. And my goal from working remotely was so that I could spend more time with all the important people in my life.
And ma'am, you did not object to the front of the court recommendation, correct?
I did not.
What are your feelings toward that recommendation while you're still under oath?
I am happy with the recommendation that it offered. I would have preferred joint or sole custody, but I realize that that is.
Well, you're both the parents of this child, and input is input. I don't think that the burden has been met at this point in time as to the parenting time in custody. I have had testimony as to, which was, I think, the main concern, child support. And he had no input in that, and the front of the court did what they did without knowledge of what his actual income was. I don't think he's been very truthful to the court, but I want to get the child support correct because this is a very high recommendation. The court's history with this type of recommendation is if you order it too high, you're getting nothing. If we order it in a manner in which it can be paid, you actually get money. So the problem is if he can prove to the front of the court that he's on state aid during that period of time, just if any party is in on zero with state aid, the front of the court will hold them to zero during that time period because state aid indicates that they are unable to work. But he would have to prove that. So I'm going to give them that opportunity. I'm going to enter the front of the court recommendation as to the parenting time, since there's no evidence to change what their recommendation was, and it actually solidifies what the two of you are doing. As to the child support, I am going to send it back. And sir, this time I'm going to confirm you are receiving mail at that Royce Road address, correct?
That is
Because
correct.
that's
Yes.
where this is going to. There will be no excuse next time if you do not show up.
At what time should I receive that mail? How long does it
Within
typically
the
take?
next 2 to 3 weeks. Mr. Browning,
Okay.
any questions?
No, Your Honor.
And by the
Thank
way,
you.
what I am also basing this off of is the attorney that was here had indicated that they filed a motion for summary disposition in this matter. So I'm basically under the current testimony stating I kind of reserved on that issue. but the court very rarely does summary disposition in these cases. But at this point, there's not enough evidence to change what the recommendation was for parenting time. So that's why
Understood.
I'm
Wait,
renew
motion,
I'm renewing your former counsel's motion, sir.
the motion for summary?
Yes, which is
Okay,
basically I'm saying as to the parenting time and the legal custody, I'm going to grant that motion on summary disposition to say the front of the court motion recommendation will enter as to child support. I'm going to say that I have enough testimony on that that's questionable, and I do want to get that correct because the child deserves money, but the child also deserves the money that can actually be paid.
okay.
Can I
So I
ask
thought
a
I'd
question?
sure.
It's a lot of legal
Yeah, I know. That's what
information
the
between you guys. So, um, for me, just so that I understand, you are in fact supporting the recommendation as far as parenting time. So I now only see my daughter 2 days per month.
you're going to see your daughter, and as you indicated in your testimony or in your statements, that you're willing to go with this and try it out, and then because we can review custody and
Yeah,
parenting time until the child's 18 and out of high
yeah.
school.
My
So,
statement was that I wanted to keep the reasonable parenting time from the pre-existing order before this was filed to change, which was 2 weekends per month.
well, and like I said, I'm renewing the motion because you presented no evidence as to how to
Okay.
change that. You
So then I
talked
would
more
have her
about
two
child support.
weekends a month.
I'm entering the recommendation of the front of the court because I'm not sure how honest you're being as to whether you live in Michigan or not.
Okay.
So,
And what can I provide to prove that?
well, like I said, you can renew another motion in a year or so, depending upon how the parenting time goes.
Okay.
All right. So I'm letting the parenting time happen in a manner in which Ms. Pimentel is willing to allow for now, and she may file a motion to curtail it if more information comes through. But you're the objecting party, not her.
Mm.
This whole recommendation could be entered, except that I do have evidence that there's something wrong with the child support issue. And I'm very disappointed that neither one of you followed through with what you should have legally, but I want to get it right. Like I said, it's been my experience that if I over order it, nobody gets anything. That doesn't help the child at all. If I get it correct, at least some attempt at payment will be done. But it is reserved back to what this I'll have to look, but I will reserve it back to when this was supposed to go. Oh, my previous order was signed on October 16th, which means it's reserved back to November 1st. So we'll see and sir, when you get that request, I suggest you send in all the information about your state aid and what's going on currently with your job.
Okay.
Because like unemployment, state aid would indicate that the state has determined that you were not employable.
Yeah.
But understand that they may hold you to an income higher based on potentially the fact that you have education and job experience. And we have such a low unemployment rate in Michigan right now that it's hard to argue that you cannot find a job, even in the field that you're saying that you're wanting one.
It's I know that seems to be true, but lower level positions, they won't
That's
hire
why
me
I'm
because
giving
I'm a
the
flight risk, and
that's why I'm giving you the opportunity to argue
I
that
thank you for
one
that.
more time.
Thank you.
Mr. Browning, any questions?
No, Your Honor.
All right.
When will we be following up regarding that child support amount then?
I will send this to the front of the court by order of reference, and I will do that. And then I will enter the front of the court recommendation as to parenting time and the
Thank
legal
you.
custody issue. All right.
Okay.
Good luck to everyone. Again, I'm renewing your former counsel's motion for summary disposition because there's no sense in continuing a name calling match that could be problematic in proofs. So let's see what we can do. And if it does not go well, Ms. Pimentel, you may file a motion to curtail it. Mr. McNamara, if it goes well, you may file a motion in the future to expand it. But you're going to have to prove that you live in Michigan.
Okay.
All right.
No problem.
Yep. It was easy the one time the guy kept telling me he lived in Chicago and it was December. And the argument was that he was in Somalia in December. Wow. And there was 12 inches of snow on the ground in Chicago.
Yeah.
And I actually asked him to pick up his phone and take me to his front porch because it was by Zoom.
Wow.
And what happened?
He was in Somalia.
Wow.
So please understand that there is a background that this court has about where do you live?
Yeah, I understand
Because the
that.
idea is everything is done here in the best interest of this child, not in the best interest of either one of you. All right. Okay.
Thank you, Your Honor.
Have a good afternoon, everyone. Take
Thank you.
care. Good luck.